Finally, Mr. Aaron Reichlin-Melnick is currently the Policy Director at the American Immigration Council, where he has also served as Policy Counsel and a staff attorney. Prior to that, he was a Justice Fellow on the Immigrant Justice Corps and the Legal Aid Society in New York. He earned a JD from Georgetown University Law Center and a BA from Brandeis University. I'd like to welcome all of our witnesses today, thank them for appearing here, and we'll begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect the witnesses have answered in the affirmative. Thank you. Please be seated. Thank you for your testimony. Next is Mr. Reichlin-Melnick.
Chairman McClintock, Ranking Member Jayapal, and distinguished members of the subcommittee. My name is Aaron Reichlin-Melnick, and I am Policy Director at the American Immigration Council, a nonprofit organization dedicated to the belief that immigrants are part of our national fabric and to ensuring that the United States provides a fair process for all immigrants, including those seeking protection. I'm grateful for the opportunity to be here today to help provide some perspective on the complicated reality of the application of immigration law at the border. At the Council, we have long brought attention through research, advocacy, and litigation to ways in which the executive branch carries out immigration enforcement. We are intimately familiar with the complex legal and practical considerations involved in the processing of migrants and have brought successful litigation against both Democratic and Republican administrations to ensure that DHS is following the law. The Constitution charges the President with faithfully executing the laws. Unfortunately for the President, Congress often passes laws which impose competing legal requirements on the executive branch. And some laws are easier to execute than others, especially in a world of limited resources. These challenges are readily apparent for immigration enforcement. As Justice Kavanaugh noted at oral arguments in Texas v. U.S. last November, there are never enough resources to detain every person who should be detained, arrest every person who should be arrested, or prosecute every person who's violated the law. Because of this hard reality, immigration officials have always been imbued with broad legal authority and with broad discretion in carrying out immigration enforcement. None other than Justice Scalia said in 1999 that at each stage of the removal process, the executive has discretion to abandon the endeavor. At the border, these countervailing concerns are critical. CBP officers are charged with simultaneously carrying out enforcement laws and humanitarian laws such as asylum. And not every person can be treated the same. There is no one-size-fits-all legal process for migrants. For example, the options available for processing a single adult arriving from Mexico arriving alone are different than those available for processing an asylum seeker from Cuba arriving with a baby. Some people can be rapidly issued an order of removal and deported. Others may require a full asylum screening, which takes time and resources. And beyond the law, congressional appropriations are finite, so there are logistical limits that are just as important as legal mandates. The use of detention is a perfect example of this. Despite laws which on their face seemingly mandate detention, Congress has never provided sufficient resources to detain every person who might be subject to mandatory detention. As a result, if there are 10 people who the law says should be detained, and only 5 ICE detention beds available, CBP must, by necessity, release the other 5. Thus, immigration officials under Republican and Democratic administrations alike have released some migrants, because while a single law might suggest they be detained, the laws in total provide alternate options. These limitations apply to all administrations. For example, data produced by the Department of Homeland Security reveals that over 1.1 million migrants were released under the Trump administration in total, including over 500,000 released at the border by CBP. Like today, these releases do not represent a failure to execute the law. Rather, they are a natural and lawful byproduct of competing legal and logistical considerations that all law enforcement agencies grapple with. Faced with a growing global displacement crisis, the Biden administration has undoubtedly struggled to manage with the resources they have. But this struggle is not unique to the Biden administration, nor is it a sign of an administration undermining the law. Instead, it is a result of outdated laws and a funding model that is badly out of balance. There are 2 million cases in the immigration court backlog, Yet today we spend $8 on immigration enforcement for every $1 we spend on immigration adjudication. The last administration spent $15 billion on border wall. That's enough to pay for 17.5 years of the current immigration court budget. So it's not a surprise then that the system is not functioning as designed, and that it takes years for the government to determine who qualifies for asylum and who does not. Moving forward, I urge Congress to undertake the difficult challenge of updating our immigration laws and providing enough resources to our adjudication systems to ensure that chaos at the border becomes a thing of the past. But Congress cannot tell the executive branch to do three things: give them enough money to do none of them adequately, and then blame the executive if it doesn't like the result. Thank you, and I look forward to your questions.